So welcome everyone this evening to, I can't believe it, the 13th annual BuckFranklin Lecture. Some of us in the room have been here for most, if not all of them, and I can't believe it's been 13 years. Just to remind everyone what this lecture is about and what it represents. So, but before I do that, I'm looking at my boss in the back row and realize I probably need to introduce him. So I'm jumping into we're really pleased to have Roger Blaze, the provost of the university, here today. I can say that it's been an interesting week at the University of Tulsa, and we really, really appreciate the provost's support, not just being here this evening, but he has been very, very supportive of the law school, and he and President Upham really helped us, with many people in this room, pave a path that's been a very positive path. So we're glad to see you here. So the Buck Colbert Franklin Memorial Civil Rights Lecture honors Buck Franklin, who was one of Oklahoma's first African American attorneys. His story I find really interesting on multiple levels. So the story that I understand is that he was practicing in one of the black towns in Oklahoma. I forget which one, and actually had decided to move to Tulsa in 1921 as a predicate of moving his whole family to Tulsa, and his timing was he arrived here just days before the race riots in 1921 and was actually stuck physically in Tulsa, but then affirmatively decided to stay to do the on-the-ground work to really help those who were victims of the race riots here in Tulsa, meanwhile separated from his family. And later, when his family reunited in Tulsa, he built for himself really a beautiful on-the-ground practice, day-to-day practice, representing members of particularly the African American community. And he was very active in a court decision striking down the city ordinance that was designed to prevent African Americans from rebuilding their homes in Tulsa after the race riots. And there's lots of stories that I have heard over the years of just not the big brush work that he did, but the just on-the-ground work with everyday people. So tonight we celebrate Buck Colbert Franklin. We celebrate his activism. We celebrate his on-the-ground in the work. We celebrate that he remained very connected to his roots in Oklahoma and his community. And we also celebrate that he paved a quiet path for his son, who is generally the more celebrated, John Hope Franklin. And I'm really proud to take ownership of, which I do think that we have taken ownership as a law school and as a university of Buck Colbert Franklin. And I can think of very few people who are more appropriate to honor his memory and his legacy than our speaker tonight, Deborah Rhode, the Ernest W. McFarland Professor of Law at Stanford Law School. I met Professor Rhode. We actually shared a cab together to the Austin airport. I met her at a Women in the Law conference, a group that I have become involved in out of the University of Texas, where she gave a tremendous talk and framed issues which I think about often, and many of you heard those issues in her interview on NPR this week, which I thought was really excellent. You have received and you have seen her bio, very long, very impressive. Just a couple highlights. Author of many books, most recently The Beauty Bias, Women in Leadership, in her discussion of that, and I thought Rich Fisher's discussion of that was extremely, extremely interesting. She is the director of the Stanford Center on the Legal Profession and the founding president of the International Association of Legal Ethics. She's also been president of the AALS, which is the Professional Association of Law Schools. Been very involved in the ABA's Commission on Women in the profession, a commission that has done critical work and continues to do, in my opinion, very critical work because we have a lot of work to do. She served as senior counsel to the minority members of the U.S. House Committee on the Judiciary during the presidential impeachment issues surrounding at the end of the Clinton administration. She's won numerous awards, just a few: the ABA Michael Frank Award for contributions to the field of professional responsibility, the ABA's Keck Foundation Award for distinguished scholarship on legal ethics, the ABA's Pro Bono Publico Award for her work on expanding public service opportunities in law schools, work that is critically important on multiple levels, and I think we need to run with in a much harder way. And also won the White House Champion of Change Award for lifetime work in increasing access to justice. I can really think of, and before that also wrote numerous articles, distinguished professor at one of the top law schools, Stanford Law School, and also a clerk to Supreme Court Justice Thurgood Marshall. I can think of really no better person to talk about civil rights issues and their impact right now in the workplace, and also to honor the legacy of Buck Franklin. So, Professor Rhode.
It's an enormous honor and pleasure to be with you this evening, honoring someone who so richly deserves the honor. And in settling on a topic, I tried to identify a subject that I thought might be related to his legacy. And in his spirit, I offer some thoughts on the paths we still need to walk in order to bring diversity and gender equity to the workplace. When I was interviewing with a prominent Chicago firm in the late 1970s, one of its leaders assured me that they had no woman problem at that firm. One of its 70-odd partners was female, and she just had no difficulty reckoning her personal and professional life. The last year, she'd given birth to her first child. It happened on a Friday, and she was back in the office the following Monday. Can you all read the captions? Well, over the last several decades, the demographic landscape has been transformed. Yet, particularly at leadership levels, progress seems stalled. And because time today is short and the subject is large, leadership is where I want to focus. One irony of this nation's continuing struggle for racial diversity and gender equity is that the profession leading that struggle, we as lawyers, have so often failed to set an example in our own organizations. Women constitute over a third of the profession, but only about a fifth of law firm partners, general counsel, Fortune 500 corporations, and law school deans. At a time when people of color, blacks, Asian Americans, Latinos, and Native Americans constitute about a third of the American population, they account for just 10% of lawyers, 6% of law firm partners, 9% of general counsel, and 19% of law school deans. Nor is law atypical. Women and minorities are underrepresented in virtually all leadership positions in business, law, and higher education. The U.S. Congress, of course, is only a fifth women and a fifth minority. Among Fortune 500 companies, men hold 3/4 of all board seats, and the breakdown of CEOs among the Fortune 500 is 96% men and 96% white. Yet the problem often lies in lack of consensus about whether there is a serious problem, what I often refer to as the no problem problem, and if so, what strategies might effectively address it. We see women and minorities in so many leadership positions now, we lose track of where they're missing. The point of today's talk is to force focus on the absences and the underlying causes, And it's not just at the Joint Chiefs of Staff level that I think we need to pay attention. And though I'll speak in general terms about women and minorities, I don't want to obscure differences among them or differences across other key dimensions such as class or ethnicity or sexual orientation. The point simply is to understand how key aspects of individual identity intersect to structure the professional experience and what can be done to promote more inclusive workplaces. Let me begin with a little bit of historical context. Until the past half-century, almost no women or minorities reached leadership positions, and almost no one in those positions considered this a problem. Both formal policies and informal practices reinforced exclusion on the basis of sex, as well as race, ethnicity, and religion. As late as 1960, when women accounted for half of college graduates, they constituted less than 3% of lawyers, and were notable for their absence at the upper level of government, law firms, and the judiciary. Minorities constituted less than 1% of the profession and were equally absent at leadership levels. As late as 1940, one survey found only 57 black women lawyers in the entire country, and the only political positions in which women of color were represented at any level was school boards. For women, the obstacles took two forms. One involved women's roles, the other involved men's preferences. For most of this nation's history, the conventional wisdom was that women lacked a legal mind and a legal temperament. And public opinion polls found that about 2/3 to 3/4 of men didn't approve of their wives working. Nor were the attitudes confined to men. In speeches and articles such as, "I gave up my law books for a cookbook," women advised married colleagues, if the man objects, for the happiness of all concerned, give it up. And many did. Surveys during the 20th century, the early part, found that only about 1/3 of women lawyers were married and only 1/4 had children. A second cluster of concerns involved not the role of women, but the distraction and discomfort of men. Administrators at Harvard worried about unchaperoned interchange in the library, at Hastings about the rustling of female skirts in the classroom, and at Columbia about the cranks and freaks who would adversely affect the school's culture and competitive edge. Other law firm and law school leaders put the problem of prejudice in more pragmatic terms. Given the discrimination and family commitments that would keep women from establishing successful careers, it just made little sense to waste a position on them. The fact of bias thus became a rationale for perpetuating it. In the absence of any accountability for restrictive policies, many decision makers saw no reason even to give a reason. When a woman barred from applying to Columbia Law School in 1922 asked the then Dean Harlan Stone, later Chief Justice of the Supreme Court, why the school wouldn't allow women, his response was, "We don't because we don't." In the few schools where small numbers of women were allowed, they were permitted to speak only on special ladies' days, where all the questions involved women's issues, like rape, or hypotheticals involving knitting and laundry. "Girl lawyer has small chance for success," ran the title of an early 20th century interview, and it was right. Discrimination based on race, religion, and ethnicity created similar obstacles for leaders of color. They bumped up against all of the racial stereotypes common in the culture: ignorant, uncouth, slovenly, lazy, as well as exclusions from bar associations and even libraries anxious to preserve the dignity of the profession. From a contemporary standpoint, what's perhaps most interesting is less the extent of discrimination than the strategies that enabled some lawyers to mount successful challenges. Some stiffened their resolve in response to suggestions that a profession was an unrealistic aspiration. The mother of Constance Baker Motley, the nation's first black female judge, proposed hairdressing instead. The teachers of one of Seattle's first Latino lawyers suggested that he train as an auto mechanic. Those who persisted often worked tirelessly to challenge policies of exclusion. Clara Foltz, the first woman attorney in California, had the satisfaction of successfully suing the school that had denied her admission, even though the victory came too late to assist her directly. She was also famous for the use of humor in response to prejudice. When an adversary suggested at trial that she'd be better off at home raising her children, Foltz responded, "A woman had better be in almost any occupation than raising a man such as you." Supreme Court Justice Thurgood Marshall also used humor to make a point. One of his famous exchanges occurred in Japan in 1950 when he was heading the NAACP's challenge to racial discrimination that was then pervasive under General MacArthur's command. The task was complicated by MacArthur's refusal to acknowledge the problem, despite ample evidence of racially disparate treatment in job assignments, promotions, and court-martials. When Marshall pointed out the absence of blacks on the entire headquarters staff, MacArthur insisted that no blacks were qualified for the positions. Marshall then pointed out that the base's military band also had no blacks and added, "Now, General, just between you and me, God damn it, don't tell me there is no African American that can play a horn." When direct confrontation appeared fruitless, these early leaders established their own institutions or attempted to fit into establishment circles by projecting a conventional image. Bella Abzug wore, I missed Thurgood. Bella Abzug, however, also famously pictured here, hat and gloves so as not to be mistaken as a secretary. But even the most demure wardrobe choices could only help so much. Supreme Court Justice Ruth Bader Ginsburg discovered the limits after tying for her first place in Columbia's law school class, but being rejected for law firm and clerkship positions. Supreme Court Justice Phyllis Frankfurter refused to consider her. "I can't stand girls in pants. Does she wear skirts?" he wanted to know. She did, but in the end he still felt too uncomfortable with the prospect of hiring a woman. Many of these early pioneers attempted to conform to traditional norms in other ways as well. Lavinia Goodall, who brought the first case challenging Wisconsin bar's exclusion of women, made sure she exhibited no other alarming eccentricity than a taste for legal studies. She taught Sunday school, attended the Benevolent Society, and made cakes and preserves. A century later, Sandra Day O'Connor broke other gender barriers through a similarly non-confrontational route. Although graduating at the top of her Stanford Law School class, she found no firm willing to hire her except as a secretary. She also took some time out after giving birth to two sons and losing her babysitter. So, as she put it, "I stayed home myself for about 5 years and took care of my family." In fact, as a biographer observed, she didn't really stay home. She became active in Republican politics and civic activities, which paved the way for later positions with the state attorney general, election to the state legislature, and, of course, appointment to the Supreme Court. She earned a reputation in her early Arizona days as a pretty little thing with a disconcerting load of expertise. I once had a conversation with Justice O'Connor about the barriers, and her husband, who had heard the stories a few times too many, finally broke in and observed, "Well, things seem to have turned out all right in the end." That was true for her, and the same was true for me, although there were a few bumps in the road. I came to Stanford over 3 decades ago as the second woman on a faculty of over 36 men. And when I indicated I wanted to teach a course in gender, the dean was horrified. "This would type me as a woman." "Well," I said with what I hoped would seem faint irony, probably wouldn't come as a surprise to most of my colleagues, and after all, what were my alternatives? But to him, I had, of course, missed the point. The point was academic credibility, and to establish that, I needed a real course. Negotiable instruments was his suggestion. Well, let's fast forward to today's lawyers. Much has certainly changed, but too much has remained the same. Women and minorities remain dramatically underrepresented at the top and overrepresented at the bottom of workplace hierarchies. Even controlling for relevant qualifications, studies find that male lawyers are 2 to 5 times more likely than women to be promoted to partners. Women and minority professionals experience greater dissatisfaction with all the dimensions of practice relevant to leadership opportunities: level of responsibility, recognition for work, chances for advancement. For example, of some 1,000 women of color in corporate counsel's office, about half said being a woman was a significant barrier. A third indicated that race was as well. Rarely do lawyers report examples of blatant or overt discrimination. And the tendency, therefore, among men is to attribute racial and gender differences to differences in choices, capabilities, and commitments. Such attitudes account for the relatively low priority that many employers attach to efforts to level the playing field for women and minorities. In one representative survey, only a quarter of white men felt strongly that it was important to increase diversity in law firms, compared with almost 9 out of 10 women of color. Another study found only 11% of lawyers believed diversity efforts were failing to address subtle racial bias, compared to 50% of women of color. Yet a vast array of evidence suggests that such perceptions understate the extent to which unconscious stereotypes, mentoring and support networks, and workplace structures disadvantage women and minorities, as well as the institutions in which they practice. So let me say a word about each of those barriers. First, gender, racial, and ethnic stereotypes. They play a well-documented role in American culture, and despite recent progress, women, particularly women of color, often lack the presumption of competence enjoyed by white men. In national surveys, at least a third to three-quarters of female lawyers believe they're held to higher standards than their colleagues, and 40% of minorities feel the same. A recent study of performance evaluations bears this out and reveals that similar descriptions of performance result in lower ratings for women. So how many of you in this room have encountered this problem? A great suggestion: let's just wait till one of the men makes it. At one law firm, a woman was denied partnership because she lacked sufficient analytic abilities, while the white male associates who had made partners were described by lawyers there as wishy-washy and immature, more sizzle than steak, and not real smart. An overview of more than 100 studies confirms that women are also rated lower when they adopt authoritative, seemingly masculine styles. What's assertive in a man seems abrasive in a woman, and female professionals risk seeming too feminine or not feminine enough. Either they're too soft or too strident, either unable to make the tough decisions or too pushy and arrogant to command respect. Self-promotion that's acceptable in men is viewed as unattractive in women. In one telling recent Stanford Business School experiment, participants received a case study about a leading venture capitalist with outstanding networking skills. Half the participants were told that the individual was Howard Roizen, the other half were told that she was Heidi Roizen. The participants rated the entrepreneurs as equally competent, but they found Howard more likable, genuine, and kind, and Heidi more aggressive, self-promoting, and power-hungry. Even the most accomplished women can encounter such bias. Brooksley Bourne, now widely acclaimed for her efforts to regulate high-risk derivatives while chair of the Commodity Futures Commission before the financial meltdown, was widely dismissed at the time as strident and a lightweight wacko. Women are also subject to double standards and double binds regarding appearance. They're held to higher standards of dress, weight, and grooming, and punished more severely when they fall short. They're also ridiculed for caring too much or too little about how they look. They can be faulted for seeming to lack self-discipline and for letting themselves go, or for seeming vain and superficial to be preoccupied with how they look. In a recent conference of utility executives, the only woman president was missing during a session, and the men joked, "There must be a sale at Saks." Other cognitive biases compound the force of traditional stereotypes. People are more likely to notice and recall information that confirms their prior assumptions than information that contradicts those assumptions. The dissonant facts are simply filtered out. So, for example, when people assume that a working mother is unlikely to be fully committed to her career, they more easily remember the times she left early than the times she stayed late. So when men leave early, they're remembered for being snags or sensitive, new age guys. But when women leave early, oh my God, who does she think she is? How unprofessional. Does she really want to work at this company? Such selective recollection may help account for a study finding that even when men and women work similar hours, over a quarter of men nonetheless thought that their female counterparts worked less, and a fifth rated the number of hours of these women as fair to poor. Minorities also encounter adverse stereotypes, assumptions that they're less competent, less industrious, and generally less qualified. Even if they have excellent credentials, they're often assumed to be beneficiaries of affirmative action rather than meritocratic selection. In a telling recent experiment, participants listened to identical recordings of a lawyer questioning a trial witness. Half the participants were given a picture and the name of a white attorney. The other half received a picture of an Asian attorney with an Asian name. Participants who believed they were free of bias nonetheless rated the white attorney as more effective, indicated they were more likely to hire him and recommend him to a friend. Similar studies find that the same resume is rated lower when it's thought to belong to a woman or to a minority. So too, when those individuals are assumed to be less competent, their failures will be recalled more readily than their achievements. A related set of obstacles involves in-group favoritism. Extensive research documents the preferences that individuals feel for members of their own groups. Loyalty, favorable evaluations, mentoring, the allocation of rewards and professional opportunities are just greater for individuals who are similar in important respects, including race, gender, and ethnicity, and here white men still have all the advantages. Outsiders find difficulty in getting access to advice, support, sponsorship, desirable assignments, and client development activities. Racial and ethnic minorities often report isolation and marginalization, while many white women similarly experience exclusion from old boys networks. The subject of tonight's discussion, why are there no women on this panel, before a panel, of course, of all men, I think speaks volumes about where we are in consciousness on this point. In some recent research, 62% of women of color and 60% of white women, but only 4% of white men had experienced exclusion from formal and informal network opportunities. Part of the problem lies in numbers. Many organizations just lack sufficient women and minorities at senior levels who have the time and the commitment to assist others on the way up. Although a growing number of these organizations have formal mentoring programs, those don't always establish adequate rewards or monitoring to ensure effectiveness. And they can't substitute for relationships that develop naturally and that yield not simply advisors, but sponsors, individuals who are willing to act as advocates and who are in positions to open opportunities. Assumptions about commitment and capabilities also keep mentors from investing in female or minority subordinates who seem unlikely to stay or to succeed. And such dynamics also put pressure on those lawyers to assimilate to prevailing norms. As one attorney of color put it, the only way to succeed in a large firm is to make them forget you're Hispanic. If a minority lawyer just doesn't fit in, the assumption is that the problem lies with the individual, not the institution. Minorities in our profession are also subject to race matching. They receive work because of their identity, not their interests, in order to create the right look in courtrooms, client presentations, recruiting, and marketing efforts. And while this strategy sometimes opens helpful opportunities, it can also place minorities in what they describe as mascot roles, in which they're not developing their own professional skills. The practice is particularly irritating when they're assumed to have skills and affinities that they in fact lack. Recent examples include a Korean associate who was given Chinese materials to review, a Japanese American asked to a meeting to solicit a Korean client, and a Latina who was assigned documents in Spanish even after she explained that she wasn't fluent in the language. "Oh, you'll be fine," she told. "Just look up anything unfamiliar in the dictionary." Linda Mabry, the first minority partner at a San Francisco firm, recounts an example in which she was asked to join a pitch to a shipping company whose general counsel was also African American. "When the firm made the pitch about the firm's relevant expertise, none of which I possessed," she said, "it was clear that the only reason I was there was to tout the firm's diversity, which was practically non-existent. In that moment, I wanted to fling myself through the plate glass window of that well-appointed conference room." Finally, a problem, especially for women, has to do with escalating workplace demands and inflexible practice structures. Hourly work quotas have risen significantly over the last quarter century, and what hasn't changed is the number of hours in the day. Technology that makes it possible for professionals to work at home also makes it increasingly impossible not to. In many leadership positions especially, expectations of constant accessibility have become the new norm, and long hours contribute to problems of stress, sleep deprivation, and other substance abuse and quality of life difficulties facing our profession. These conditions of practice have made leadership positions unattractive to many women, especially those with significant family responsibilities. All work and no play is fast becoming the norm in many professional workplaces. And often the assumption is that because women choose not to adjust their lives to meet these responsibilities, the fault and the fix lie with women themselves. In a front-page Sunday New York Times article about the opt-out revolution, the author notes the underrepresentation of women as leaders and asks, "Well, why don't women rule the world?" Maybe, she suggests, it's because they don't want to. But explanations based on women's choices ignore all the ways that those choices are constructed and constrained. And if women aren't choosing to run the world, it's partly because men aren't choosing to run a vacuum cleaner. Despite a significant increase in men's domestic work over the last 2 decades, women continue to shoulder the major burden. In one study of lawyers, women were 7 times more likely than men to be working part-time or to be out of the labor force, primarily due to child care. 40% of high-achieving women feel that their husbands make more work around the house than they actually contribute. It is still women who are most likely to get the phone call that federal judge Nancy Gertner received on the first day that she was about to ascend the bench. "Mama, there's no chocolate pudding in my lunch." Yet women who assume disproportionate family responsibilities are in workplaces designed primarily by and for men, and despite some efforts at accommodations, a wide gap persists between formal policies and actual practices concerning work-life conflicts. For example, although over 90% of American law firms report policies permitting part-time work, only about 6% of lawyers actually use them. Many professionals believe, with good reason, that any reduction in hours or availability would jeopardize their leadership opportunities. America is the only nation in the developed world that doesn't offer paid parental leave. A federal statute that guarantees 3 months of unpaid leave covers only half the workforce, and most of those who are eligible don't take advantage of it, partly because it's unpaid and partly because they worry that it would signal a lack of commitment. Stories of the faster-than-a-speeding-bullet maternity leave, like the one that opened this lecture, are still common. One pregnant lawyer I know drafted responses to pretrial requests for information while timing her contractions. Well, she figured, if you're billing at 6-minute intervals, why waste one? Those who opt for reduced schedules after parental leave often find that it isn't worth the price. Their schedules aren't respected, their hours creep up, the quality of their assignments goes down, the pay is not proportional, and they're stigmatized as slackers. Wherever they are, at work or at home, they have the sense that they probably should be somewhere else. So what's to be done? Well, I think the first challenge is to overcome the sense among many lawyers that these problems are not serious problems in their workplaces, or that responsibility for addressing them lies anywhere and everywhere else. A second challenge is to develop organizational policies and cultures that are committed to equal opportunity, not just in principle, but in practice. And a third challenge is to help aspiring leaders overcome subtle forms of bias. Let me just suggest a couple of strategies and then invite your suggestions in the question and answer period. First of all, what doesn't work? Well, at the individual level, certainly litigation. To be sure, you occasionally read about multi-million-dollar discrimination remedies and you hear about smoking gun evidence, like the accountant who brought in the highest billings but wasn't promoted and instead was told she needed courses in charm school, better makeup and jewelry, and a more demure style. But those cases are rare exceptions. At leadership levels, winning is highly unusual, and even those who win in court often lose in the world outside it. The more subjective the qualifications, the harder it is to prove that race or gender is the major reason for an adverse decision. Plaintiffs are putting their lives on trial, and the pictures that emerge are seldom wholly favorable. In a recent case involving sexual orientation discrimination, which was settled, it wasn't settled before the male plaintiff was described in a major New York magazine as a smarmy, paranoid kid with a persecution complex. What also doesn't work are token programs like diversity training. These are the most popular diversity initiatives, though large-scale research finds they're the least effective and don't correlate with higher levels of women and minorities in upper-level positions. The reason is that they're generally poorly designed and often serve to entrench backlash. My husband, a public interest environmental lawyer, recently came home from a training in which they were all supposed to learn how to deal with cultural differences through team building. He had to pick a team name, sing a team song, and choose a team logo, and then to his horror, actually sing the song. He came home fuming about a day lost to pointless kumbaya exercises. So enough about what doesn't work, what does? And what can individuals do to place themselves on the path to leadership? Well, individuals can seek out mentors and challenging assignments. Surveys of successful managers and professionals also underscore the importance of developing a professional style that fits the organization, and for women is one that men are comfortable with. This finding is profoundly irritating to some women, of course. I recall at an ABA summit on women's leadership, many participants railed against asking women to adjust to men's needs. Why was the focus always on fixing the female? But as others pointed out, this is the world that aspiring women leaders inhabit, and they need ways of projecting a decisive and forceful manner without seeming arrogant or abrasive. Experts suggest being relentlessly pleasant without backing down. Women can also follow the advice that Sheryl Sandberg, the CEO of Facebook, put in her widely circulated TED Talk. Make your partner, she said. Particularly if women want children and don't want to be just married to their jobs, women need to find partners who believe in sharing the work, not just in principle, but in practice. Ruth Bader Ginsburg tells the story about when she was litigating Supreme Court cases and her husband was a tax partner in a New York law firm. Their son was having some behavioral issues at school, and the teachers and principals always called her when there was a problem. Finally, once, in exasperation, she said, "This child has two parents." And miraculously, the calls stopped. Apparently, the problems weren't significant enough to bother her presumably busier husband. At the institutional level, what can be done? Well, support for diversity needs to be reflected in organizational policies, priorities, and reward structures. The commitment needs to come from the top. An organization's leadership needs not simply to acknowledge the importance of gender equity, but to establish structures for assessing and promoting it, and to hold individuals accountable for results. So, for example, firms need not just to establish a part-time policy, but to monitor who uses it. And if it's few individuals, find out what's standing in the way and what can be done to make it more user-friendly. Bottom-up evaluations in which supervisors are rated on issues such as diversity and equity can help increase accountability and are far too rare in most firms. A final strategy is formal mentoring programs and networks for women and minorities. At their best, these can provide useful advice and support, role models, contacts, and forge relationships. By bringing potential leaders together around common interests, these kinds of networks can help build coalitions on diversity-related issues and generate useful proposals for reform. Organizations can also do more to expand the pipeline to professional careers for minorities. An example is Skadden & Arps, a Wall Street firm that partners with schools in low-income areas to improve minority performance and aspirations. And as one American Bar Association official put it, that's great. Now all we need is hundreds of other firms to make that same commitment. Organizations that are most effective in these efforts are those that cast their agenda not as women's issues or minority issues, but as institutional priorities in which women and minorities have a particular stake. As consultants emphasize, inclusion can be built only through inclusion. Change needs to happen in partnership with people of organizations, not to them. Leaders are critical to creating that sense of unity and translating rhetorical commitments into organizational priorities. And I'm so grateful to all of you for showing up tonight to discuss how we might make that happen. So thank you.
Professor Rhode has agreed to answer some questions, and I'm going to take the privilege of asking the first one. So, and you mentioned this in your NPR interview, this summer, it seems like, and you referred to the opt-out piece in the New York Times, it seems like periodically we're getting pieces, and this summer a piece came out by Anne-Marie Slaughter called Why Women Still Can't Have It All, that led to sort of a firestorm of responses, led me to a whole lot of introspection, and I thought your response was interesting and very insightful on NPR, but I know that you have written about it, and I'm wondering if you could share with us some of your thoughts about the points raised in the piece and any reaction to it in light of what you just shared with us.
Well, I found the piece very frustrating, possibly for the same reasons that you did. First of all, it was completely mislabeled. Women can't have it all. Well, here's a Princeton professor who's gone back to a full-time, well-paid, high-status job where she has total control over her own schedule and can afford close to full-time help. You know, if that's not having it all, I don't know what qualifies. What she couldn't have was a particular job in a city in which her family didn't reside, and one that happened to have extremely long hours, given the nature of the work. But her experience is not atypical in either of those jobs, one with almost no control over the workplace structure, one with almost complete control over hours and scheduling. Most of us live somewhere in between, and somewhere in between those workplaces, for reasons I indicated in the lecture, haven't really done nearly enough to accommodate work-family conflicts. The fact that only 6% of lawyers feel entitled to use part-time policies speaks volumes about the progress yet to be made. And what was additionally frustrating about the article was she had no solutions. It's not like she's the first person who's pointed out the difficulties in reconciling work and family life. And, you know, what she suggested was, gee, we ought to, you know, elect a woman president. Well, you know, from her lips to God's ears, but if she thinks that would even solve the workplace problem, I think all recorded evidence is to the contrary. We need leaders at all levels to care about those issues. We need ways of holding them accountable. We need incentives and monitoring structures that are going to make sure that policies that are out there in principle work in practice. I also must admit to a little frustration about hearing how much our president has managed to accommodate his work and family life, making it home for dinner at 6:30 almost every evening. We heard about it again at the Democratic convention. Well, he lives over the shop. And unfortunately, what also happens, according to White House staffers, is because he's able to do that, he comes back to work at 8:30, and those who don't live over the shop don't have time to go home, get dinner for their family, and be back to meet him at 8:30. So it means that somebody else is paying the price for that accommodation. And that's where we need to start rethinking what the structures actually look like, when it's the people who work for the president and the people who work in the president's kitchen and the staff can afford adequate and quality child care, where they have access to meaningful part-time work. Then we'll be a little distance towards solving the can't have it all problem. I don't think that article really pointed us in particularly productive directions. Yes?
One thought that I've had is whether this is changing over generations. I had a really interesting interview with somebody who was applying for a summer associate position who asked about work-life balance. And what was interesting was that this was a male who asked this. And I just wonder if it's more, as we get younger, that the younger people have more of an idea of this, as the generations change, and what your thoughts are on that.
I do think all the research indicates that men are coming to share the same, increasingly coming to share the same preferences and to being frustrated by the same kinds of workplace conflicts that women face. So the fact that he's asking that question is, I think, not atypical of this generation, and also is a really hopeful sign. I remember Gloria Steinem was speaking at Stanford a number of years ago, and she was asked a perennial question about how women could reconcile and deal with the work-family conflict. And she said, women can't until men are asking that question too. We're now getting to the point where more and more men are asking that question. And more women are expecting their spouses to ask the question. And I think that way, together with the shifting demographics of the profession, really does give some cause for hope. We've seen enormous changes just in the space of my generation. We wouldn't have had this lecture or someone like me giving it when I went to law school. So we're partway there. We've recognized the problem. We've put it on the agenda. And I think we're getting to a point in which more and more men are aspiring to a kind of quality of life that's been out of reach for them as well as women. Yes?
I work in a law firm that deals with a lot of corporations, and I'm sure you're familiar with the call to action that was signed, and I don't know how long ago now, maybe 10 years ago, by a lot of the Fortune 500, and then more recently it's called Council on Legal Diversity. Its signatories are 70 of the major corporations in the country, and both of these efforts represent statements by major corporations that attempt or purport to attempt to affect the diversity in outside law firms that they hire. The call to action was a statement by all these general counsels that they would take the diversity of law firms into account whenever they engaged outside counsel. And the more recent effort, I think it's the Legal Counsel on Law Firm Diversity, something like that. Their statement was even more specific than that, and that is when law firms participate in what they call beauty contests. They're bidding competitions to get a piece of work from one of these businesses, that the businesses will not only look at the diversity of the law firms that are bidding, but will require that a diverse person actually lead the team on the job, not just on the bid, because that was what you were talking about. I mean, the typical little playground that was being run was they'd stick a minority or a woman out there to lead the bid, but then when it came to assigning the work, it would be a white male who took the lead and everything. So these large businesses are making an effort to push diversity for women and minorities in law firms. But one of the I thought really telling things that I learned recently, I was at the Minority Corporate Counsel Association annual diversity program in New York City earlier this week, and on one of the panels that I attended, an African American woman, in-house counsel at one of the few large airlines left in the United States, talked about her company's requirements regarding diversity and when they seek outside counsel. And this airline happens to be a client of ours, and I know well that we have to report all of our diversity stuff to them. But when asked about diversity in their shop and work-life balance efforts and the availability of alternate work arrangements so that if people wanted or needed to work at home, they could, she said, that is simply not available in our company. Our general counsel has said, you be here, whatever, you be here. And I think that kind of hypocrisy sends out it sends out the true message. It's all very well and good to sign all this junk and say, all of you law firms, you get it together out there, while your statistics on the general counsels of major corporations say a whole lot more about what's really the priority in the corporations.
Yeah. Well, the Leadership Council came to Stanford last year and gave our annual lecture to Representative Michelle Mays. Told a similar story, and gotta walk the walk along with talking the talk. I think it's true, and there are a lot of ironies here. Walmart has been a leader of this effort. Has among the toughest policies, even requires one of the partners to be on a part-time schedule. I mean, it's really micromanaging its selection, whereas its own workplace practices have been, how shall we put it, possibly not above reproach.
Yeah.
So we need to pay attention to both dimensions of diversity and gender equity efforts. Yes.
Wonderful talk. It strikes me that these barriers in the legal profession to women and minorities actually impose a great cost on corporations and other consumers of legal services, because these barriers ultimately deny consumers of legal services access to the highest quality providers of those legal services. And I have a question for you. With the legal profession becoming more global and with the economy becoming more global and international and focused on delivery of the best quality legal services for the invested dollar, do you think those pushes coming from the consumers of legal services might tend to erode some of these barriers over time? I think of the time where women were denied access to any profession except school teaching, and that provided a low-cost labor pool for school teachers, but it also denied our citizenry in general access to the better trained, high-quality individuals who could access the profession. So I was just wondering whether some of these global economic trends might provide some kind of a push against some of these barriers.
Yeah, I think they do. Certainly in a highly competitive legal marketplace, you can't afford to create an atmosphere that isn't fully inclusive to such a large share of the incoming talent. And, you know, with half the new entrants to the profession now women, I think it just stands to reason that the most competitive institutions are going to be the ones who actually manage to figure out how to make it work. So the demographics in the long run are with us, but in the short term, there's still some work to be done. Yes?
I just wanted to make a comment. I'm Native American. I grew up on an Indian reservation, and I'm probably from the older generation, but it's wonderful that in this land that we have opportunities. However, I would like to point out that at a very basic level, in the home is where children are taught to be respectful of other cultures, to be tolerant, and to be accepting. And you can also have in homes of very highly educated people prejudice, bigotry, racism that is taught and it's passed down from generation to generation. I worked in the public sector in the Clinton administration and the U.S. Department of Justice. And I found at the U.S. Department of Justice there was injustice. So I just thought I would share that with you.
Yeah. Thank you for that comment. Yes?
I've been listening to what you've said, and one of the things that keeps coming back into my mind is the phrase, every wife needs a wife. And until, I'm thinking of my son and his wife and the life they lead in Washington, D.C. And quite honestly, she doesn't have time to get pregnant. She wouldn't have time to raise a child. Neither one of them. When the dog dies, they're not going to replace the dog because they don't have time to train the dog until the whole workplace, whether it's male, female, Martian or not, determines that the work day is not 18 hours. We're going to have a problem to the point where, you know, you're going to start having freeway accidents just because everybody's asleep. And then maybe people will wake up. But it is not really even any longer a male-female issue. It is what can a human being do in 24 hours?
Yeah.
And, you know.
Here again, I'm hopeful that you're going to see some pushback from clients on this, because nobody gets good service from bleary, burned-out lawyers, and the smartest general counsel are looking at those hourly sheets, and you know they don't want to see somebody who's billing 14 hours a day on their matters. So I think being more realistic about what's likely to produce high-quality services just has to be part of the equation in a competitive legal marketplace. I think there's reason to be optimistic that maybe folks will realize that we've pretty much reached the limits of human endurance, and that we've got to cut back in order to make it possible for people to have some kind of a reasonable family life. And it's not just caring for children, it's also increasingly, as the population ages, caring for elderly parents as well. So we're needing to find ways to handle this juggling act in a way that takes it on as an institutional and a societal obligation, not just as a personal problem. And on that partially optimistic note, thank you so much.